Ms. Mathie was driving through a school zone during after-school pickup. There was a traffic snarl and she was caught behind other vehicles. She might perhaps have overtaken them by swinging out onto the wrong side of the road, but she judged that to be unsafe. She later said, "If there's a big line of traffic and a car has just come out of a cross street, I'm not going to overtake on the wrong side of the road, past a street with kids all over the place, pedestrians everywhere. It's just not safe." It seems that some parents outside this particular school were in the habit of double parking while collecting their kids. A traffic inspector photographed Ms. Mathie's car and she later received a fine for being double parked. She challenged the fine all the way to the Court of Appeal. South Australian law, as elsewhere in Australia, says you cannot just stop your car on the roadway unless you're doing so for a valid reason, such as stopping at a stoplight or if you're stopping in order to comply with another road rule. The Court of Appeal found that anyone relying on that defence bore the burden of proof. So if the prosecution has proved that I stopped my car on the road and I say this was to comply with some other rule, then it's on me to prove that's why I stopped. At trial, Ms. Mathie represented herself. Nobody told her that she had to prove her defence, even once her defence became obvious. Indeed, the trial was conducted on the basis that she, as the defendant, didn't need to prove anything. The Court of Appeal found that this was a miscarriage of justice. Their Honours said, "No explanation was provided to the respondent as to the operation of the rules, nor as to the applicable persuasive burden of proof, and what she needed to establish to bring her circumstances within the exception. Indeed, the trial proceeded on the basis that the respondent had nothing to prove. In those circumstances, we consider there has been a miscarriage of justice." From this case, we learn that in traffic matters where the defendant is self-represented, they should be advised of any defences which seem to be open to them on the facts which emerge at trial, especially if they bear the burden of proving that defence.